Expired. I therefore have no option but to call on Government Order of the Day number 1.
Public Safety, Public Protection Orders Bill, interrupted debate on first reading.
When this debate was last taking place in the People's House, the Honourable Member Dennis O'Rourke was speaking, addressing this chamber, and I understand, Mr O'Rourke, that you have 8 minutes remaining.
Thank you, Mr Speaker.
I call the Honourable Member Dennis O'Rourke.
I have said, Mr Speaker, that I agree that provided the bill incorporates the key standards, safeguards necessary for a civil committal regime, it will be civil rights compliant. Whether the bill as introduced includes adequate safeguards is what the Select Committee must closely examine. In doing so, it will be necessary to ensure that the detailed provisions of the bill will observe the principles as stated in it. Firstly, not to punish persons, and the previous commission of an offence to be only one of several factors that are relevant to assessing whether there is a very high risk of imminent sexual or violent offending. Secondly, a protection order should only be imposed if the magnitude of the risk posed by the respondent justifies it. Thirdly, a protection order should not be imposed on a person who is eligible to be detained under the mental health legislation. And fourthly, persons who are detained in a residence should have as much autonomy and equality of life as possible. Those are the principles that the Select Committee needs to keep in mind when reviewing this bill. The threshold for an order requires that the person is a prisoner under a determinate sentence for a serious sexual or violent offence, is to be released from detention not later than 6 months after the date of the application, or is a prisoner under the Parole Act, or is subject to a protective supervision order. This threshold appears to us to be appropriate, and an order should only be needed really. The bill requires a robust assessment of whether a subject poses a high risk of serious sexual or violent offending. It requires the application to be supported by at least 2 reports, one of which must be by a registered psychologist and the other by either a psychiatrist or another psychologist. And the court may call for a report by a health assessor, and the respondent to the application can also request such a report. So those are good safeguards. And this, of course, is the crux of the main issue, that there must be proof of whether an order is necessary. That's most important. And in addition, the court must not find that there is a very high risk of further offending unless it is satisfied that the respondent exhibits a severe disturbance in behavioural functioning established by evidence of specified characteristics to a high level. And I think that's also a very important safeguard. The review provisions will also need to be examined by the Select Committee, and that is something which we really need to have a close look at as to whether those review provisions are adequate. A person may be detained in a prison or in a residence if the person is subject to a protection order but not to a prison detention order. The residence is a building located in prison precincts. A resident has the rights of a person of full capacity who is not subject to a protection order. And specific rights of residents include retention of earnings from permitted employment, the right to vote, to get newspapers, to have internet access, and to use written communications and receive permitted visitors. So these are not persons without rights. They will have their freedom severely limited, but it's not like being in prison. So there's a good balance there, I believe. The bill provides for inspections of residences at least twice a year, and an inspector can in fact arrive and make an inspection at any time unannounced. And the bill confers jurisdiction on the court to order that a person be detained in a prison instead of a residence if the court is satisfied that the person would, if detained in a residence, pose an unacceptably high risk to the person or to others. Mr Speaker, New Zealand First welcomes the bill, which we think is needed to fill a gap in the law, a gap which the public sees and believes should be filled. The gap allows dangerous prisoners who are not mentally ill to be released with great risk to the public, and we've seen some evidence of that in the past. Against this, of course, we must not allow unnecessary or arbitrary detention, and therefore New Zealand First will take great interest in the detail of the bill at the Select Committee stage to ensure that the balance of which I have spoken, personal rights versus public protection, are adequately achieved.
I call the Honourable